so it's not.
Well, good morning. It's 8:45. We're going to call this public notice hearing of the Commissioners Court of Grimes County. It's Wednesday, December the 20th, 2017. The time is 8:45 in the morning. Our agenda item is to consider the application and hear any protest to the replat of King Oak, Section 1, that combines Lot 211, or 211, that is 2.744 acres, and Lot 212, that is 2.572 acres, into a single lot to be redesignated as Lot 211-R for a total of 5.312 acres.
There it comes.
Sorry, Judge. We're waiting on you, sir.
You already started it?
We've already started it.
All right. Judge, Commissioners, and public, this is a public hearing to consider the request to replat, grab a little bit there, a section of King Oaks. And I provided a copy of this before, so some of you may still have the original one that I provided to you, but this is a large example of that. Ooh, okay.
Take your time.
Yeah, we've got time.
Yeah.
15 minutes.
It shows the original layout in King Oak Section 1 of plat, or lots number 212 and 211, and then how it would look once they're combined.
Okay. Thank you.
Sure.
And these are, we've done a number of these over the last several years, sir, so this is becoming a routine, but as a part of the process, whenever there's a change to a plat, we have to provide a public hearing before we actually decide on it.
Yeah, they're basically not able to build on that property line without changing the plat.
Mm-hmm. Mr. Lilly, is there anything else that we need to be concerned about with this replatting?
I don't see any issues with it, sir. Both lots were of sufficient size and had sufficient access onto Gloucester Avenue. Gloucester, how do you say that? Gloucester. It's a cul-de-sac, and now this will be a larger lot that has even more access onto that cul-de-sac.
Okay. Well, since you were a little bit rushed getting here, we're gonna keep this meeting open just in case somebody else is maybe a little rushed getting here. We have the time allocated and we're dedicated to that, so.
Yeah, and in the 5 years that I've been doing these, we've never had anybody come and say anything, but again, as a part of the requirement for these, whenever there's a change to a public record, we have to provide that form for somebody that may have a concern. Just for the record, Judge, this one did come up a couple of times due to issues as far as recording and so on. We just had to table it until today, but that has not been a problem for the developer or the landowner.
Mr. County Attorney,
Yes, sir.
sneeze and cough if this question's out of order, okay? What are the fees and costs associated with this, David, as far as to the county? Does the landowner pay anything to have this done? Does the developer pay anything?
The landowner normally is the one, yes, there is a replat fee that they pay to the county, and then also once the plat is approved, then there's a filing fee with the county clerk's office.
Do you know what those costs are or charges are?
It's based on the acreage for the replat fee, and it's half of what the normal plat fee would be, so I'd have to refer to my subdivision rules to see what exactly that fee would be. They've already paid the fee for that.
Okay.
And then the filing fees, Mr. Paskett handles that.
They're gonna, excuse my voice is just about gone.
Understood,
They're
Judge.
gonna be approximately $150. But I'll throw this in. I'm having to buy a new plat cabinet that's gonna cost somewhere between $4,500 and $5,000. It is mainly due to King Oak refile. I doubt that our charges for refiling will pay for that plat.
That
That's
cabinet,
just my guess. I'm sorry.
you said you doubt that it would pay for the cabinet?
That's right.
Okay.
Yeah, because every replat is filed with the original plat, and it's, like I said, over 5 years, Dave, how many, I lost count,
I can't keep count.
so,
Besides the public hearing, it doesn't have to run in the paper, does it?
no. Well, the public hearing was advertised in the paper. I take care of that too, so that's
Okay,
part
so-
of, that's what the replat fee helps to cover my expenses as far as listing it in the local paper, because it has to be advertised, and also, you know, for covering my time with the county.
Okay, so the 150 he's talking about, is he's talking about that's just your office, or is that to?
Yeah, there's
Just
two
in my
separate.
office.
Yes, ma'am.
And I'm not saying this to be negative towards King Oaks in any
No.
way, shape, form, or fashion. But if every developer had this situation, we would have to have a separate building to house the plants.
Well, and also, one of the considerations, I would think, that as we have more and more of our areas developed, if they come in with these smaller subdivision lots, and ultimately we believe that they're going to consolidate and come to bigger lots, instead of having 100 houses in that development, we end up with 50 houses in that development. So for our long-term planning, you know, maybe not this week or next year, but taking a look 2, 3, 5 years down the road, where we're trying to encourage people to come to the county and build that tax base, so we spread it amongst everybody. Just an awareness on our part as a court as to how often we allow this to happen. We certainly want to make Grimes County a desirable place to live and not have a lot of restrictions, but just a
And
thought.
just for comparison, the other major development that we're still working with is Crown Ranch. In 5 years, I think I've done maybe 2 of these. Most of theirs, they marketed to larger lots to develop, or landowners that wanted to build on larger lots. From what I understand, the original plan with King Oaks, they wanted to actually make larger lots, but the way it was explained to me was that to be able to get favorable financing to pay for building it out, the bank wanted to see smaller lots. Now, that's the way it was presented to me, but I think their intent all along was to be a larger lot subdivision. So that does bring up a good point, Judge, something maybe we can talk sidebar after this is to look at, and we're always looking at ways to revise our subdivision rules. With the new development that we know is coming to the county, we want to maybe look at making sure that future developers don't take this route. You know, if they're gonna develop for smaller lots, then stay with smaller. And we can't stop them from combining, but this one, I agree with Mr. Paskett, this one has been wholesale. I mean, like I said, I could go back and survey how many I've done in 5 years, but there's been a lot. It's become routine.
But you
Crown
also
Ranch is
have,
gonna do smaller lots on the southern part of that.
Right, but
Like it
those,
told us.
when I understand, they intend on keeping those small
Yeah.
lots. They're selling to the market where people can't afford the bigger lots.
Yeah.
So, but they're not looking to combine those.
well, the positive thing is it's gonna be revenue for the county once they build on lots. And
Right.
perhaps with smaller lot, they could only build a certain size house, whereas with the lots being larger, they can build a larger house. And the good thing is the activity that King Ranch has is producing bigger revenue. I mean, that's some of the largest, with our our voting base, that's one of the larger growing areas is King Ranch. So although we might have some fees that we're having to absorb because they're replatting, it's
Right.
still a good thing that the activity's there.
Small investment on our part.
Judge, could I ask that you consider adjourning the meeting?
Sure.
'Cause you can have this discussion when we get on to the regular agenda, and it's set to hear any protests, and I wanna be sure we don't go too far afield.
Certainly. Is there any other questions, discussion? Is there a motion?
I move we adjourn.
Second.
All in favor, say aye.
Aye.
Any opposed? Carries. All right, we are recessed till 9 o'clock.